Good morning. This is your Kelso Report for Friday, July 13th, and I'm your host, Clark Kelso. We begin with a Ninth Circuit case involving mortgages. The plaintiff in Gale v. First Franklin Loan Services sent a letter to the defendant, a loan servicer, regarding ownership of his loan. The defendant did not send any reply back to the plaintiff, and the plaintiff then sued, alleging a violation of the Truth in Lending Act and the state law covenant of good faith and fair dealing. Well, the Ninth Circuit rejected these claims, noting that a breach of good manners is not always an invasion of any legal right, and that a loan servicer has no duty to respond to such a letter. The court did remand for further consideration of a more traditional state law claim for what ultimately was a wrongful foreclosure. Next, we have an antitrust case from the Ninth Circuit. The plaintiffs, who are ATM card holders like all of us, alleged horizontal price fixing of fees paid to the ATM owners by the banks. You know, those fees when cardholders retrieve cash from an ATM not owned by their bank. Well, turns out the plaintiffs, that's us, we do not directly pay the allegedly fixed fee. And so that makes us indirect purchasers. And under the indirect purchaser rule of Illinois BRIC, the plaintiffs lacked standing to bring their antitrust claim. The only way around Illinois BRIC would be if there was a conspiracy to fix the price paid by the plaintiffs, which the plaintiffs did not allege, or the banks were all controlled by each other or by the ATM network, neither of which was the case. So this particular federal antitrust action has come to a quick close. Next, in Michelman v. Lincoln National Life, the Ninth Circuit held that an interpleader action is proper when a stakeholder has at least a good faith belief that there are conflicting, colorable claims. Now, on the facts presented in this case, the court concluded that the defendant life insurance company had a good faith belief based on a phone call from the ex-spouse of the policy owner, who informed the company that he believed he was co-owner, and he had not approved the change to the beneficiary designation in the policy. The court found enough ambiguity in the policy so that the competing claim was not frivolous, and the competing claimant was taking active steps towards filing a lawsuit. In these circumstances, it was clear the insurance company had a real and a reasonable fear of colorable conflicting claims, making the interpleader proper. Next, we have a case from the Supreme Court of California involving the definition of lesser included offenses in the escape from prison context. In People v. Bailey, the Supreme Court faced the issue of whether, after finding insufficient evidence to support a conviction for escape from state prison, an appellate court could reduce the conviction to attempt to escape, notwithstanding the trial court's failure to instruct the jury on attempt. The court unanimously held that it would have been improper to reduce the conviction to attempt to escape, because intent to escape requires a specific intention to escape element that is not present in the crime of escape, and therefore attempt to escape is not a lesser included offense of escape. You gotta wonder, how could this happen in the escape context? Well, factually, the defendant had cut his way out of his cell and cut through 4 fences, but he was still within the outer perimeter fence, and so he arguably had not yet committed the escape. As for attempted escape, the defendant argued that his intention was actually to cut through to another yard to attack an inmate. He was not intending to escape from the prison. Well, since the lower court did not instruct on attempt and the jury made no findings regarding intention, there was no basis for the appellate court to reduce the escape charge to attempt to escape. And that's it for today's Kelso Report. Have a great day in the law.